Alright, let's talk straight. So many of you out there think you have a handle on estate planning, you hear the term, and you nod. You think, oh yeah, that's about a will, right? I'll get to it someday. Or worse, you believe you've already got it all figured out with a few beneficiary designations here and there. But let me tell you, my friends, that is a dangerous, dangerous assumption. Understanding true estate planning is far more complex, far more nuanced than most people realize. It is not just about who gets your favorite lamp or your stock portfolio when you are gone. It is about protecting your legacy, your loved ones, and ensuring your wishes are truly honored without causing them a mountain of heartache and financial pain. The reality is, what you know about estate planning can seriously hurt your family. It is not just about having a will, that is only one piece of a much larger puzzle. Do you understand how trusts work? Do you know the implications of joint ownership? Have you considered incapacity planning? These are not just fancy terms for the wealthy, these are critical components for almost everyone. Believing that a simple will covers all your bases, or that naming your kids on your bank account is sufficient, is like thinking a band-aid can fix a broken leg. It is a temporary, often ineffective solution that ignores the much deeper issues lurking beneath the surface, waiting to cause chaos. Many people confuse estate planning with simply deciding who gets what. They believe if they have verbally told their children their wishes, or jotted down a few notes, that everything will magically fall into place. This could not be further from the truth. The legal system does not operate on verbal promises or scribbled notes, it operates on properly executed, legally binding documents. Without these, your intentions can be completely disregarded, leading to family disputes, costly legal battles, and your assets not going where you wanted. This is not the legacy you want to leave behind, is it? A legacy of confusion, conflict, and unnecessary expense for the people you care about most. So the first step is acknowledging that maybe, just maybe, you don't have it all figured out. And that is okay. It is far better to admit that now, on this day, May 20th, 2025, and take action, than to let your family pay the price for overconfidence or procrastination later. Estate planning is about taking control of your financial future and the future of your loved ones. It is about making informed decisions, not just hopeful assumptions. It is about ensuring that what you have worked so hard for is protected and distributed according to your explicit desires, not left to chance or the impersonal machinations of the court system. Listen to me on this one. It is that important. Now, let's dig into a common pitfall that seems so simple on the surface but can create a world of trouble. I am talking about those pay-on-death or POD accounts, sometimes called transfer-on-death or TOD for investment accounts. You go to the bank, you fill out a form, you name your child as the beneficiary, you think, perfect, so easy. When I pass, little Johnny gets the money directly. No fuss, no muss, no probate. Oh, if only it were that straightforward. While these accounts can be useful in some very specific situations, they can become an absolute nightmare if the beneficiary you name is a minor child. You heard me right, a nightmare. Think about it. Banks and financial institutions cannot and will not simply hand over a large sum of money to a 7-year-old, or even a 17-year-old. Minors are not legally able to own or manage significant assets directly. So what happens to that easy account when you pass away and your minor child is the named beneficiary? The court gets involved, that's what. A judge will likely have to appoint a legal guardian of the property for your child. This person, who may or may not be who you would have chosen, will then manage that money under strict court supervision. This means legal fees, accounting requirements, and a whole lot of bureaucratic red tape. This court-appointed guardian will have to get permission for how the money is spent. Can you imagine? Needing a judge's approval for your child's school trip or braces, paid for with money you intended for their care? Furthermore, once your child reaches the age of majority, typically 18 or 21 depending on your state, they get the entire sum outright. All of it. Think back to when you were 18. Would you have been responsible enough to handle a significant inheritance? For many young adults, that sudden windfall can be overwhelming and frankly mismanaged or squandered very quickly. This is likely not the careful, long-term financial security you envisioned for them. This single, seemingly straightforward beneficiary designation can unravel your best intentions. Instead of a smooth transfer, you have created a situation that requires court intervention, incurs additional costs, imposes restrictions, and potentially hands over a lump sum to an unprepared young adult. Proper estate planning, perhaps through a trust for minors or a custodial account established under the Uniform Transfers to Minors Act, UTMA, could have entirely avoided this mess. These tools allow you to specify who manages the money for what purposes, and at what age or stages your child receives the funds. It is about control and protection, which a simple POD designation for a minor simply cannot provide. If you think getting professional help with estate planning now is expensive, just wait until you see the bills your family will face if you have a proper plan in place. I am not kidding you. The cost of sorting out a messy estate, or an estate with no plan at all, can be astronomical. We are talking about significant legal fees, court costs, appraiser fees, accountant fees. The list goes on and on. These expenses eat away at the very assets you worked so hard to build, leaving less for your loved ones. It is like throwing money down a black hole, all because of a failure to plan ahead. Can you really afford for your family to go through that? When you die without a clear, legally sound estate plan, your estate often ends up in probate court. Probate is the legal process of validating a will, if one exists, and distributing assets. If there's no will, or if the will is flawed, or if your plan relies on those simple solutions we just talked about that go wrong, the probate process can become incredibly complicated and drawn out. It can take months, sometimes even years, for your family to access their inheritance. During this time, assets might be frozen, bills might pile up, and your loved ones are left in a state of financial limbo and immense stress, all while grieving. Think about the emotional toll this takes. Your family is already dealing with the grief of losing you. The last thing they need is to be burdened with a complex, confusing, and contentious legal battle over your estate. Arguments can erupt between family members, even those who previously got along. Relationships can be permanently damaged. This is the unfortunate reality when wishes are unclear, or when the legal framework to execute those wishes is missing. The stress, the anger, the resentment, these are the hidden costs that do not show up on an invoice, but are just as devastating, if not more so, than the financial ones. Compare this nightmare scenario to the relatively modest cost of sitting down with a qualified estate planning attorney today. Yes, there is an upfront investment, but it is an investment in peace of mind. It is an investment in protecting your assets. It is an investment in sparing your family from a prolonged, expensive, and emotionally draining ordeal. A well-crafted estate plan can minimize or even avoid probate altogether, ensure your assets are distributed quickly and efficiently, and provide clear instructions that prevent family disputes. So you have a choice. Pay a little now for a solid plan, or let your family pay a whole lot more later in money, time, and tears. The smart choice is obvious. So many people think estate planning is only about what happens after they die. Who gets the house? Who gets the money? But let me be very clear. A comprehensive estate plan is just as much, if not more, about protecting while you are still alive. It is about ensuring your wishes are followed and you are cared for if you become unable to make decisions for yourself. This is where documents like a healthcare power of attorney and a financial power of attorney become absolutely critical. These are not just pieces of paper, they are your voice when you may not be able to speak for yourself. A healthcare power of attorney, sometimes called a healthcare proxy or advance directive, allows you to appoint someone you trust to make medical decisions on your behalf if you become incapacitated. Imagine you are in an accident or suffer a sudden illness and cannot communicate your wishes to doctors. Who do you want making those life-altering decisions? Do you want it to be a person you chose, someone who knows your values and what you would want? Or do you want to leave it up to chance, or worse, to a court-appointed guardian who knows nothing about you? This document ensures your medical preferences are respected and that someone you trust is in charge. Similarly, a durable financial power of attorney allows you to designate someone to manage your financial affairs if you are unable to do so. This person can pay your bills, manage your investments, file your taxes, and handle other financial matters. Without this document, if you become incapacitated, your family might have to go to court to get a conservatorship or guardianship appointed to access your accounts just to pay your mortgage or medical expenses. This is, again, a costly, time-consuming, and public process that can be entirely avoided with proper planning. You want someone you handpicked handling your money, not a stranger or someone chosen by a judge after a lengthy delay? Having these documents in place is an act of profound self-respect and consideration for your loved ones. It removes an enormous burden from their shoulders during an already difficult time. They will know they are acting according to your wishes, not guessing or fighting over what to do. Your estate plan, therefore, is not just a death plan. It is a life plan too. It provides a clear roadmap for managing your affairs and your well-being, no matter what life throws your way. It is about maintaining control over your own life and your own decisions, even if you cannot voice them yourself. Don't you want that peace of mind? Section 5. Blended and beautiful. Planning for modern family structures. Life is not always a straight line, is it? Many families today are beautifully blended with second marriages, stepchildren, and children from previous relationships. These modern family structures bring so much joy, but they also bring unique complexities when it comes to estate planning. If you are in a blended family, a simple will or relying on beneficiary designations alone is almost certainly not going to cut it. In fact, it can be a recipe for disaster, inadvertently disinheriting loved ones or sparking intense family conflicts after you're gone. You must be incredibly thoughtful and deliberate in your planning. Consider this common scenario. You remarry, and you want to provide for your new spouse after you pass. But you also want to ensure that your children from your first marriage eventually receive their inheritance. If you simply leave everything outright to your new spouse, what guarantee do you have that your children will ever see a penny? Your surviving spouse could remarry, could spend all the assets, or could change their own will to leave everything to their own children, effectively cutting your children out. This happens more often than you think, and it is heartbreaking for the children who feel forgotten or betrayed by a lack of careful planning. This is where tools like trusts become invaluable for blended families. For example, a qualified terminable interest property trust, or QTIP trust, can be set up to provide for your surviving spouse for their lifetime. They can receive income from the trust and perhaps even access the principal for certain needs like health and support. But then, after your surviving spouse passes away, the remaining assets in the trust go to your children, as you originally intended. This way you take care of your spouse while also protecting the inheritance for your children. It's about finding that balance and ensuring fairness for everyone involved. Without careful planning, state laws of intestacy, or poorly drafted documents, can lead to unintended consequences that do not reflect your true wishes. You might accidentally disinherit your own children, or leave your current spouse without adequate resources. The key is to have open conversations if possible, but most importantly, to work with an experienced estate planning attorney who understands the dynamics of blended families. They can help you structure a plan that addresses your specific situation, minimizes potential conflicts, and ensures all your loved ones are provided for in the way you desire. Do not leave this to chance. Your family's harmony depends on it. Section 6. Beyond I Do. Protecting unmarried partners and single parents. The traditional image of a family has evolved, and so too must our approach to estate planning. Let's talk about unmarried couples. Whether you have been together for 2 years or 20 years, if you are not legally married, the law in most states offers very little, if any, automatic protection or inheritance rights to your surviving partner. You could live together, share expenses, build a life together, but if you pass away without a specific estate plan naming your partner, they could be left with absolutely nothing. Your assets would likely pass to your closest blood relatives according to state intestacy laws, potentially leaving your partner out in the cold, both emotionally and financially. This is a harsh reality, but it is one you must face if you are in a committed, unmarried relationship. Your partner might not have any rights to your shared home, your bank accounts, or any of your assets, unless you explicitly provide for them in a will, a trust, or through other legal means like joint ownership with rights of survivorship or beneficiary designations. Think about the devastation. Your partner is grieving your loss and simultaneously facing the possibility of financial ruin or even being forced to leave the home you shared. This is not an oversight you want to be responsible for. A proper estate plan is your way of legally recognizing and protecting your partner. Now, let's consider single parents. If you are raising a child on your own, estate planning is not just important, it is absolutely non-negotiable. Your primary concern is undoubtedly the well-being of your child. What happens to them if something happens to you? Who will raise them? Who will manage the money you leave behind for their care and education? If you do not legally nominate a guardian for your minor child in a will, a court will make that decision. A judge who does not know you or your child or your family dynamics will choose who takes on this immense responsibility. Is that a risk you are willing to take with your child's future? Furthermore, you need to plan how your assets will be managed for your child. As we discussed earlier, leaving assets outright to a minor is problematic. You will want to consider setting up a trust that names a trustee to manage the funds until your child reaches an age, or ages, that you deem appropriate for them to handle the money themselves. You can specify how the money can be used, for education, healthcare, living expenses, and so on. For single parents, an estate plan is the ultimate act of love and protection for your child, ensuring their care and financial security are in place, no matter what. Do not delay this, your child is counting on you. Section 7. Caring for all special considerations for families with special needs. For families blessed with a child or another loved one with special needs, estate planning takes on an even deeper level of importance and complexity. Your primary goal is to ensure your loved one continues to receive the care, support, and quality of life they deserve long after you are gone. However, a direct inheritance, even with the best intentions, can inadvertently jeopardize the very government benefits your loved one relies on, such as supplemental security income and Medicaid. These programs have strict asset and income limits, and a sudden inheritance could disqualify them, leading to a loss of essential medical care and financial support. This is where a special needs trust, also known as a supplemental needs trust, becomes an absolutely essential tool. This type of trust is specifically designed to hold assets for the benefit of a person with disabilities, without those assets counting against them for purposes of qualifying for public benefits. The funds in the trust are not paid directly to your loved one, but are instead managed by a trustee whom you appoint. The trustee can then use the funds to pay for supplemental needs, things not covered by government benefits that enhance your loved one's quality of life. This could include things like specialized equipment, therapy, education, recreation, and travel. Setting up a special needs trust requires careful drafting by an attorney experienced in this specialized area of law. It is not a do-it-yourself project. The rules are complex, and mistakes can have devastating consequences for your loved one's eligibility for benefits. You will need to choose a trustee carefully, someone who is responsible, trustworthy, and understands the unique needs of your family member, or perhaps a professional corporate trustee. You also need to fund the trust either during your lifetime or through your will or other beneficiary designations upon your death. This ensures the resources are there when needed. Beyond the trust itself, your overall estate plan should be coordinated. This includes communicating with other family members who might also want to leave something to your loved one with special needs. You want to ensure they also direct any gifts or inheritances into the special needs trust rather than directly to the individual. A comprehensive plan, including a letter of intent that outlines your loved one's routines, preferences, medical needs, and your hopes for their future, can provide invaluable guidance to future caregivers and trustees. This is about providing lifelong security and dignity for your most vulnerable family members. It is a profound responsibility and an incredible gift. Section 8. Uncle Sam's Plan for You and Why You Might Not Like It. Alright, so what happens if you just do nothing? You keep putting off estate planning, thinking it is too complicated, or you are too young, or you just do not have enough assets to worry about. Well, let me tell you, the government has a plan for you. It is called the Laws of Intestate Succession. And trust me when I say, Uncle Sam's plan for distributing your hard-earned assets might look very, very different from what you would have wanted if you die intestate, meaning without a valid will. The state where you legally reside steps in and dictates who gets what. These intestacy laws are rigid, one-size-fits-all formulas. They do not care about your personal relationships, your specific wishes, or the unique circumstances of your family. Typically, these laws prioritize spouses and children, then parents, then siblings, and so on, down the line of blood relatives. If you are married with children, your spouse might get a portion and your children get a portion, but the exact shares can vary significantly by state. What if you wanted your spouse to receive everything to ensure their security? The state's plan might not allow that. What if you have a strained relationship with one of your children and wish to leave them less? Too bad, the state's formula applies. Think about some of the family situations we have discussed. If you are an unmarried couple, your partner will likely get nothing under intestacy laws, no matter how long you have been together or how much you intended for them to inherit. Your assets could go to distant relatives you barely know instead of the person who shared your life. If you are in a blended family and you haven't legally adopted your stepchildren, they will typically be excluded under intestacy. Your assets might go entirely to your biological children, even if you considered your stepchildren as your own and wanted to provide for them. The state's plan rarely reflects the complexities of modern families. Furthermore, if you have minor children and die intestate, the court will appoint a guardian for them, as we have discussed. The court will also control any inheritance they receive until they reach the age of majority, at which point they get it all in a lump sum. There is no provision for managing funds for their long-term benefit, no staggering of distributions, no trustee you selected. The process is public, can be costly, and often leads to outcomes you would never have chosen. Relying on the government's default plan is essentially abdicating your responsibility and your right to decide what happens to your legacy and how your loved ones are cared for. It is a gamble, and the stakes are far too high. Section 9. Stop procrastinating, start planning, your future self and your family. Well, thank you. We have covered a lot today, haven't we? We have talked about the common misunderstandings surrounding estate planning, the hidden pitfalls like those involving minors, and the staggering costs, both financial and emotional, of not having a plan. We have explored the critical importance of healthcare and financial powers of attorney for protecting you during your lifetime. We have delved into the unique needs of blended families, unmarried couples, single parents, and families with special needs children. And we have seen why the government's default plan is rarely the plan you would choose for yourself. The message, I hope, is crystal clear. You need an estate plan. Procrastination is your biggest enemy here. I hear all the excuses: I'm too young, I don't have enough assets, it's too complicated, I'll get to it later. But later has a nasty habit of becoming too late. None of us knows what tomorrow holds. An accident or illness can strike at any age, at any time. And not having enough assets, even a modest estate, can become a source of contention and legal fees if not properly planned. The truth is, if you care about anyone, your spouse, your children, your partner, your parents, your friends, even your beloved pets, or if you care about how you are treated if you become incapacitated, then you need an estate plan. Taking action now, on this day, May 20th, 2025, is one of the most responsible and loving things you can do for yourself and your family. Think of the peace of mind you will have knowing that your affairs are in order, that your wishes will be honored, and that your loved ones will be protected from unnecessary hardship and conflict. This is not about dwelling on death. It is about living your life more fully, knowing you have taken care of these important responsibilities. It is about removing a heavy weight from your shoulders, and from the future shoulders of those you care about most. So, what is your next step? It is simple. Connect with an experienced estate planning attorney through our collaborative platform. Not your brother-in-law who dabbles in law, not an online form that promises a cheap and easy solution. You need personalized advice from a professional who understands your specific situation, your state's laws, and your unique family dynamics. Yes, it will take some time. Yes, it will cost some money. But as we have discussed, the cost of not doing it is infinitely higher. Stop making excuses. Stop putting it off. Make the call. Start the conversation. For your own and your family's well-being, taking this step is crucial. It is achievable and necessary. If you require legal assistance, please leave a comment and our team will connect you with an attorney.